So this morning I'm going to talk to you a little bit about an important aspect of a business, that is setting up the business in the correct structure. Everybody says it's a good idea to start a business, and indeed it is, but it's not always that easy, and it's not easy to know where to start. As a business founder, you will have a lot of things to think about, and one of the things is the structure, and that's all I can unfortunately help you with in those stages, and that's what we'll be talking about. I have asked the organizers to circulate my slides to you, so I'm going to go through a couple of these slides fairly quickly because of our available time. But and you'll be able to go through the slides afterwards to get some of the information that you might miss now. But the common forms of businesses is sole proprietor. A lot of you will be conducting your business in your own name. There's a partnership, that is if you are 2 or 3 partners, but actually it's in your own name. You don't have a registered company structure. The registered structures are closed corporations, that is the CC or a company. A trust is also an option, but it's less common. I'm going to be focusing more on company structures this morning. These are some of the slides that you would be welcome to peruse afterwards, and obviously if there are any questions that come from that, you can give me a call. The most common forms of companies are private companies. Those are your Pty Limiteds, the ones that you will know best. They are obviously for profit. Then you have non-profit companies. All of you have heard of them and have been involved in some of them, hopefully, and some of you might even be conducting non-profit companies. That is where you have a social objective, probably, or an environmental objective, but you do not have shareholders and you are not trying to make profit. An important thing to remember there is you are entitled to make profit and to maybe you have some product that you sell. If you make a profit, those profits must just be used in supporting the objective of the company. Just a side note. We also know about public companies. Those are the ones on the JSE, and personal liability companies such as doctors, lawyers, auditors, and so on. So something that we find when dealing with SMEs is that the structure of a company is not always properly understood, and it's important for you to understand it. If you misunderstand it, you will conduct the business of the company incorrectly, and that could cause damages or loss or even liability. So the company is basically structured as you will see there. The first important thing is to always keep in mind is that the company itself is its own legal entity. It is a person on its own. It is not you. And you and the company are not the same. Even if you are the sole shareholder, even if you hold 100% of the shares, you must distinguish between yourself and the company. So the shareholders there on top, we always just draw it in this fashion. They are basically the owners of the company. They can be, well, there has to be at least one shareholder, but there can be many more. And they will hold a number of the shares, and it will translate to a percentage of the ownership. The directors, they are the hands and feet of the company, the managers of the company. They are involved in the day-to-day running of the company. And of course, every company or most companies will need employees. An individual can be on all 3 levels. You can be a shareholder and a director and an employee. You need not be. You can be a shareholder with no other involvement in the company, or you can be a director without being shareholder as well. Obviously, most employees are not shareholders as well, but the distinction between these 3 are very important. So if we look at the shares and the shareholders, first of all, a company is created with a number of authorized shares. That is almost akin to stock on the shelf that you can sell. Once you've sold those shares, it becomes issued shares. You do not need to sell all your shares or issue all your shares, but at least one share must be issued to a shareholder so that you have an owner of the company. You start off with a limited number of authorized shares, but you can increase that to at a later stage when you take in new shareholders. once you issue that share sits in the estate of the person who holds it, of the shareholder, and that shareholder owns the share. It's very much like a person owning a car. You cannot take that share back simply because you feel like it. He has the right to sell that share. He's got certain benefits because he has the share. It has a certain value in his estate. I've said that the shareholders are the owners of the company, but they are not involved in the day-to-day management of the company as much as the directors. They do have a measure of control. The big decisions go to the shareholders. So for instance, if there's a problem and there must be a liquidation, then the shareholders has the authority to do that. Authorizing new shares would be something for the shareholders and so on. So it's very high-level decisions and not the day-to-day running of the company. The benefit of being a shareholder, of course, is that you're there for the profits. The moment the company starts making a profit, you will share in that profit in relation to your shareholding. And the risk is limited. We'll look at the exposure of directors in a minute. But for shareholders, it's limited. A shareholder can never be held liable for the debts of the company. The risk you face as a shareholder is that you can lose your investment. If you invest in a company and the company does not succeed or survive, you cannot go and recoup the money that you've put in, or the time or other investment that you've put into the company. You cannot recoup that from anybody. That is your risk. So directors, we must have at least one director in a PTY Limited. If you are one of the non-profit companies that we have here today, then you must make sure that you have at least 3 directors. You wouldn't have been able to register a non-profit company with only 2 directors. The directors, as I've said, they are responsible for the day-to-day running of the company. And it's not a position that you should accept lightly. It's very nice to say that I'm a director of my company, but as a director, you must make sure that you are capable of running the company. We see in the common law, they talk about a fiduciary duty. You might have heard of that. That just simply means it is the highest standard of care that you need to apply when you deal with the affairs of the company. It is actually considered that you need to take care of the affairs of the company with a higher degree of skill than, and care than you would have taken care of your own affairs, because you are dealing with the asset and the property of the shareholders and not your own. Now, you're going to say, yeah, but what if I am the shareholder? Sure, but remember, we are distinguishing in our roles as shareholders and as directors. So please keep that distinction in your minds at all time. And the risk of being a director is also something to consider. You might have heard of people saying, I'm sorry, I just want to see if there's a message I need to consider. We'll get to the questions and answers later. Just quickly answer Karen there. If you're a shareholder, if there's one shareholder, you will be 100% shareholder. If there are 2, you can decide it can be 1% for the one and 90% for the other, or 50-50. Okay, and then yes, like I said, there's a personal liability. So you might have heard of the piercing the corporate veil. So this is when a company goes on, it's trading recklessly, it's making a lot of debts and incurring a lot of debts and buying stuff, and it's not paying its creditors because it's not actually surviving, it's not doing good business. And the creditors are the ones actually at the end of the day not being paid and who is suffering a loss. When a creditor wants to issue action against that company, it can consider to issue action against the director or the directors in their personal capacity as well. He will have to make a case to show that the director conducted the business of the company recklessly. So it's very easy to say that I'm hiding behind my company, and the debts of the company is not my problem. But as a director, if you take it too far, the creditors can come after you personally. So that's something to be careful about, and not to be misunderstood, thinking that you're safe, and actually there is a risk there. So I just want to stress this because we've seen so many problems that arise from this. You must distinguish in your role as a shareholder and a director, and you must distinguish that from the company itself, especially if you're a sole shareholder and you're the only director in your company. If somebody pays you in your personal name, they haven't paid the company. Yes, the effect is fairly the same, but the company must issue its own invoices. It must collect its own fees. It must pay its own expenses. Then the company can make a profit, and that profit can come to you as a shareholder. You shouldn't sideline the structure and take payments directly, and so you're going to run into trouble, and you're going to confuse the roles. The moment you start dealing with more than one shareholder, it's very important to make sure that your company documents are in order. A shareholders agreement is the primary document that will regulate the relationship between the shareholders. And equally important is the memorandum of incorporation. So that's basically the provisions of the Act to a large extent. And there are many provisions there that regulate the relationship of the shareholders. If those documents are not in place, you do not understand exactly the terms of your relationship, and you're going to run into, or should you run into, a dispute, you won't have a way of resolving that or dealing with that. Now, in my next session, a little bit later, we're going to look at agreements, and I'll indicate to you why it's so important to have proper agreements in place. What I want to just stress here is the moment you start bringing in further shareholders is when you need to make sure that you have a shareholders agreement in place. That's just to remind you. Advantages of the companies, there's continuity. Should the shareholders pass away, the company can proceed, or the directors pass away, the company proceeds, and the business of the company is preserved. There is protection for the owners, and there's a large extent also protection for the directors. It's a very structured and a regulated environment. It gives a lot of credibility to your business. There are tax structures that you can use to optimize your tax liabilities and to reduce that liability. And then if you're the only shareholder and the only director, there is provision for, or if you're a small company with multiple shareholders, multiple directors, there is provision for a simpler structure so that it's not, you don't need to do audits and go through all that pain. We're running out of time very quickly. This is just one issue that I want to explain a little bit more detail. When you have a company and you've set it up, you've gone through the initial growth phase, and you're actually making a profit, but now you need that little bit of extra cash, a capital injection to take you to the next level, maybe to buy an extra vehicle or a bigger premises, or maybe to pay off some debt so that you can just start growing again. This is where having a company is very useful, because you can sell those shares then. Now, the sale price of the shares, the input of the investor, can assist the company. Or the other way of doing it is that you sell your shares and you actually get some money in your pocket. All your sweat and hard work over the last couple of years of building this business is now resulted in you, when you sell some of your shares, maybe not all of it, you get some money in your pocket that you can enjoy for your personal benefit. So there's a lot to consider there, and I would advise you to rather get an attorney, see an attorney who specializes in these matters before you enter into an agreement where you sell shares, because it's a very tricky thing. I've even seen instances, many in fact, where clients sell the shares because the other party says, I will do X, Y, and Z. And then he gives the shares, and then he has the shareholder, and you can't get rid of him. Remember, I said shares are like a vehicle in that person's asset. You can't just take the vehicle away. You can't take the assets back simply because there's a dispute. So you are basically stuck with him as a shareholder. Two ways that this can happen. If A is the sole shareholder and B wants to make an investment, then A can sell shares to B for R1 million. That means the R1 million flows over to A, and 50 of the shares flow over to B. Now we have 2 shareholders in the company, and A has R1 million in his pocket. But of course, when I invest in a company and I invest R1 million in the company, I want that company to have access to those funds. I want the company to be able to use those funds to make the company bigger, so that the company that I have shares in is a stronger company. So then what happens, the investor will rather insist that the company issue more shares to him, and then he pays that R1 million to the company. Now you would say, A is last year, sure, he's lost 50% of the ownership of the company, but as we say, it's a smaller slice of a bigger pie. So potentially that company should grow and make profit, and he should get more profit at the end of the day. Now there is a way around that. Sorry, I don't have a slide for that. Is for the first scenario rather to take place, A will pay the money to B will pay the money to A, but on the agreement that A will loan the money back to the company as a loan. A might not have the funds in his pocket, but he does have the asset of a loan against the company, which will be repaid hopefully in due course. And B has the benefit that the company in which he now owns shares has the, it's this scenario, he has the R1 million capital to expand his business. So when you get to the point where you want to start bringing in investors, please consider the options and get somebody to help you with that, to properly set it up. Companies are slightly more complex, and there are some disadvantages to that. So it's more onerous to manage it, and it needs to be considered. There are just 2 slides for closed corporations and trusts. And there was a mention of SME legal. I just want to mention in my last seconds that we are running a special for the attendees. If you go to the website, there's a lot of information on SME legal there, and we are running a 30% discount for everybody who uses this TSP 2021 discount code, and you would be able to access a lot of our resources, all of our resources there.